Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya, and in today's discussion we are going to see a very important part that has been placed in the Honorable Supreme Court of India. The title of our today's discussion is Article 136, which talks about the Special Leave Petition. In this discussion, we are going to study about what is a SLP. We are also going to see the circumstances in which a Special Leave Petition can be filed. Then we are also going to analyze the scope of power that is given to the Supreme Court under this article, and in the end we are going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, recently an SLP has been filed by the NewsClick founders and other members who have been arrested under the Unlawful Activities Prevention Act, stating that arrest is not legal in the eyes of law and hence we should be freed. So they are challenging their arrest and remand under the UAPA Act. So this brings us to the moot question of our today's discussion, that what is a special leave petition? So if I talk about the special leave petition, as the word itself suggests that it is a special power that is given to the Honorable Supreme Court of India. So if I talk about the appellate jurisdiction of the Supreme Court, appellate jurisdiction of the SC, it is given under articles 132 to 134 of our Indian Constitution. But this power under article 136 is over and above the ordinary appellate jurisdiction of the Supreme Court. We have a maxim in administrative law, a very famous maxim, which states that the justice must not only be done, but it also must seem to be done. What do I mean by this statement? That you should not only do justice to the aggrieved party, but it should also be seen that you are doing justice to the aggrieved party. So what happens under article 136 is, if there is an aggrieved party, okay, and there is an important question of law that has not been answered in his case under the original appellate jurisdiction of the Supreme Court under articles 132 to 134, or there is a need for the Supreme Court to intervene immediately, then what the aggrieved party can do, it can approach the Supreme Court by filing a special leave petition under article 136 of our Indian Constitution. Article 136 of our Indian Constitution empowers the Supreme Court to grant special leave to appeal from judgment, decree, determination, sentence, or order. So judgment, decree, determination, sentence or order against any court or tribunal in India. And this distinguishes this article from articles 132 to 134. Under articles 132 to 134, you can only appeal against the judgment given by the High Court. But in this case, this is not so. You can appeal against the judgment of any court or tribunal located within the territory of India, the only exception being the Armed Forces Tribunal. The decision of whose is not appealable directly to the Supreme Court. But apart from those cases, you can present a special leave petition to the Supreme Court under this article against the judgment of any court or tribunal in the territory of India. Then the Supreme Court is also empowered to intervene in any case or matter. It is not confined to civil cases or criminal cases, as is the case in articles 132 to 134. It talks about only civil or criminal appellate jurisdiction of the Supreme Court. But this article, under this article, the Supreme Court can intervene in any case, no matter what the nature of the case is. Then another important distinction of this article and appellate jurisdiction of Supreme Court under articles 132 to 134 is, the article 136 clause 1 mentions the word order. It does not mention the word final order, as is the case in these articles, that is articles 132 to 134. That means the Supreme Court can also intervene while the proceedings are still going on. If there has been an interim order or an interlocutory order, then also the Supreme Court can intervene while the case is still going on. It does not need to wait for the final order to come. So this is a very special power that has been given to the Honorable Supreme Court of India, and it empowers the Supreme Court to do complete justice in certain matters and provide justice to the aggrieved party. Now let us understand the circumstances in which an SLP can be filed. So an SLP can be filed against any judgment or decree or order of any High Court or tribunal in the territory of India. So this is what I was explaining to you before, that the SLP is not restricted to the final orders or orders against the High Court. It can be filed against the judgment, order, decree, sentence, determination of any court or tribunal within the territory of India, and the time frame is within 90 days from the date of the judgment. SLP can also be filed in the case the High Court refuses to grant the certificate of fitness for appeal to the Supreme Court of India within 60 days. So this certificate of fitness is granted under Article 134 Clause A of the Indian Constitution, under which the High Court grants that, okay, this case involves a very important question of law that needs to be decided by the Supreme Court itself, and hence we are granting you a certificate of fitness. You can go now in the Supreme Court and appeal. So if the High Court refuses to grant this certificate of fitness to the appeal to the Supreme Court, then also the aggrieved party can approach the Supreme Court through a special leave petition within 60 days of the judgment. Any aggrieved party can file SLP against the judgment or order of refusal of grant of certificate. So this is what I was explaining to you, that they can file and directly file an SLP if the High Court refuses to grant this certificate of fitness. Now let us determine, or let us analyze the scope of the power of the Supreme Court under this article. So as we all know, the power of the Supreme Court under Article 136 is completely discretionary in nature. What do this word discretionary means? That it is completely the prerogative of the Supreme Court. You cannot claim that SLP is my right and I have a right to the approach to the Supreme Court by way of a special leave petition. And that is why SLP is known as a special leave petition, and it is not known as a special leave application or something like that. When the Supreme Court determines the prima facie case, or the Supreme Court sees that, okay, this is a very important question of law which we must determine in order to do complete justice, then the Supreme Court decides to whether refuse to admit the SLP or grant the special leave to appeal. And when this special leave to appeal is granted, then this petition is converted into a normal appeal. And that is why we are not mentioning this word appeal, rather we are mentioning the word petition here, because it is a complete discretion of the Supreme Court whether or not to admit the petition. It cannot be claimed as a matter of right by the aggrieved party. So this is what I was explaining to you, that you do not have a locus standi, direct locus standi. You cannot go to the Supreme Court and say that, okay, I want to file an SLP and you will have to admit my SLP. No, this does not happen. You have a right under ordinary appellate jurisdiction of the Supreme Court under Articles 132 to 134. That is your right, but SLP is not your right. It is completely the discretion of the Supreme Court. And it is a very residual power that is given to the Supreme Court to do complete justice. That means it is not a plenary power, because Article 136 does not mention any word that qualifies it to be a right of the aggrieved party. So that is why it is a residuary power. It is a special power. It is a extraordinary power granted to the Honorable Supreme Court of India to determine the important question of law as well as to grant complete justice to the aggrieved party. So this was all about the special leave petition. With this, we come to a conclusion of our today's discussion. We have seen what is a special leave of petition. We have also seen the circumstances under which the SLP can be filed. We have also examined the scope of power given to the Supreme Court under Article 136 of the Indian Constitution, and we have also seen that this is a discretionary power. That means Article 136 is a extraordinary device. It is not your normal right. You cannot claim it as a matter of right. It is completely the discretion of the Supreme Court whether to admit this petition or not to admit this petition. So this was all about the special leave petition. Now let us see a practice question for your prelims examination. So the question is, consider the following statements. Your statement number 1 is, Article 136 of the Indian Constitution allows the Supreme Court to grant special leave to appeal. Your statement number 2 is, SLP can be filed as a matter of right. Which of the following statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us see a practice question for your mains examination. So the question is, comment on the scope of power guaranteed to the Supreme Court under Article 136 of the Constitution of India. So firstly, you will write what is a special leave petition. You will also write the circumstances in which it can be filed. You will also write that this is a very extraordinary device that is used by the Supreme Court to do complete justice in certain cases. You will also mention that you cannot claim it as a matter of right, and you will also say that this is a discretionary power. But you will write that it has a very wide scope and it cannot even be limited by Articles 132 to 134. That means the Supreme Court can overlook these articles while deciding a SLP. So this is a very important part that has been granted to our Honorable Supreme Court of India, and you can conclude holistically that this is very necessary because in certain circumstances the aggrieved party has no option but to immediately approach to the Supreme Court for having justice or for asking justice from the Supreme Court of India. So you can have a holistic conclusion that this power is very important, as our constitution is very dynamic in nature and there are certain circumstances which require immediate redressal. So you can conclude very holistically. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you found today's discussion to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.